Thank you all for joining today's session. My name is John Pollack. I'm the coordinator of the National Coalition for a Civil Right to Counsel. And we are a organization with about 600 participants and partners in 41 states around the country that support efforts to establish and implement a right to counsel in basic human needs cases. Housing is a big part of the area in which we work, and we're thrilled to have an opportunity to talk to you about ways to advance that movement. Noelle?
Thanks, John. My name is Noelle Porter. I'm the Director of Government Affairs for the National Housing Law Project. And on behalf of our organization, as well as the National Low Income Housing Coalition, we have been working closely with John on efforts to engage around evictions. And our sort of key effort is always to ensure that there is more representation. And John and the coalition are doing that work, whether it's right to counsel or just continuing to find ways, like we do in this presentation, to tap existing federal funds and do the work that we need to do to keep folks safely housed. So I'm gonna turn it back over to the coalition to run the meeting, but thank you so much for allowing us to be co-host and to get this important message out.
Thank you. So I'm gonna ask my speakers to introduce themselves, and Jim is definitely not Jim, so apologies for that. Jim, would you like to introduce yourself first?
Gladly, John, and I could maybe get used to that name, but it would take a little getting used to. Hi, everyone. I'm Jim Shaftsma. I am the housing attorney at the Michigan Poverty Law Program, and it's good to be with you today.
And Jennifer?
Good afternoon, everyone. I'm Jennifer Wood. I'm the director at the Rhode Island Center for Justice, and excited to have this conversation with you today.
Hazel?
Hi, everyone. I'm Hazel Remish. I'm with the Legal Aid Society of Cleveland. I'm one of the supervising attorneys in our housing practice group, and I am currently leading the right to counsel work. It's nice to be here.
Barbara?
Yes, hi, good morning. My name is Barbara Schultz. I'm the Director of Housing Justice at Legal Aid Foundation of Los Angeles, and I'm overseeing our right to counsel work, as well as other things.
Thank you. And Ugochi?
Hi, good morning, everybody. Ugochi Annabera Nicholson, pronouns she, her, hers. I'm the directing attorney for our Housing and Homelessness Prevention Unit at the Public Law Center in Santa Ana, California. Thank you for the opportunity to join all of you today. We are working on emergency rental assistance programs with different cities in our region.
Thank you. So today's session is going to be, I'm going to take a few minutes to just briefly say a few things about the right to counsel and outline what these funding sources are, so that we have that in mind. And then our terrific speakers are going to talk about how they've used this, gotten the money, and what they're using it for in their jurisdictions. We will be sharing a 4-pager that's as short as we could make it, with the basic parameters of these funding sources, so that people can see how they're different from each other and how they work. So you don't have to worry about taking frantic notes during this presentation. The funding portion, the federal sources, we're going to give you that information in a much better form after this webinar. So just to quickly say, the reason why we're talking about right to counsel today, what's potentially at stake in an eviction is basically every kind of basic human need that a person can have. Obviously their shelter, but their health, their employment, their children's access to school, their child custody, all of these things are potentially at risk in an eviction. It's not just about the house itself. The massive imbalance of power between landlords and tenants, 90-10 is the figure we usually give, like 90% of landlords and 10% of tenants are represented. The tenant representation rate is usually never as high as 10%. It's usually more around 5% or 1%, but we use 10% just to be safe. From a race equity standpoint, we know that people of color are far more frequently in eviction proceedings, and there's actually terrific data from Matt Desmond and from the census showing exactly the disparity, especially for Black women in eviction proceedings. I wish we had time to go into that today, but we don't. But just to say that's out there. The legal complexity of evictions, which was always significant even before COVID and has gotten even more so during the pandemic. Even non-payment of rent cases are, there are many defenses potentially available. And even when there are no defenses for a tenant, the questions of whether the eviction is formally entered, how long the tenant has to leave, the amount of arrears. These are extremely important questions that have to be answered in most eviction proceedings. So the need is there pretty much across the board. And then lastly, we have tremendous data showing the impact of counsel in housing cases, both from in terms of improving outcomes and in terms of cost savings. There's tremendous information out there that we'll share with you after the webinar today. Where we are right now, basically, is we have 8 cities that have enacted a right to counsel, which are currently up there. And we have 8 states that are considering legislation. And actually, yes, last night, Maryland's bill got through the House and the Senate and is on the way to the governor. So Maryland is on the way to being the first state. And also Washington State has also passed the House and the Senate. It has some reconciliation left, but it's very, very close to passing. The other bills, some of them have already gotten hearings and are at various places, but that's really exciting to have 8 states already considering a right to counsel in 1 year. We have some more states and jurisdictions on the way. There's been also federal interest in this issue. So this is just a really exciting time when you look at how recent a lot of this is, 2017 really being the first, from just then into now in 4 years, how far we've gotten. And the success stories from right to counsel, 86% of represented tenants remaining in their homes in New York, 67% in San Francisco, 93% of represented tenants avoiding an eviction in Cleveland. The proof is there, not just from the studies we had before a right to counsel, but since the right to counsel's come out, it's confirmed everything that we already knew about the effectiveness that these programs would have. So these are the reasons why you should be thinking about using these funds to look at right to counsel in your jurisdictions. And now I'm going to just really quickly go through what these funding sources are so we can really spend the bulk of our time hearing from the places using these. So the CARES Act is the first one. People are probably already familiar with the CARES Act. It passed last year. The biggest pot in the CARES Act, the Coronavirus Relief Fund, is very flexible in how it could be used. Any other COVID-related expenses reasonably necessary to the function of government is, a very broad usage statement. Its money is available until the end of this year. The other 2 sources, the CDBG and ESG monies, are programs that existed before COVID. They just got additional funding and they have their own parameters on them. And the deadlines are for CDBG are kind of complicated, and we didn't want to get into this in this slide. But basically, the gist of it is that CRF, CDBG, and ESG are all potentially available sources for providing tenant representation, and have in fact been used for tenant representation all over the country in 2020. And you're going to hear about a new one this year in 2021. A lot of states did not spend their CARES Act money, in part because originally the CDRF part was supposed to expire at the end of December 2020. And then at the last minute, they extended the deadline. And a lot of states had not spent the money because they were concerned about an audit and worried that they were not going to be able to use it correctly. So now they have more time to use it, and they may not have allocated it all. And as we say down there, over 25 jurisdictions have used CRF, ESG, or CDBG CV for legal aid. So this is not a theoretical thing. This has been happening now for quite some time with the CARES Act pots. The second pot, and these are ones that were created very recently. The ERAP stands for the Emergency Rental Assistance Program. We don't have time to go into all the details, except to basically the thing to understand from these pots is that while the bulk of the money for the emergency rental assistance programs was intended to go directly into the hands of landlords and tenants to pay for rent, up to 10% of that money can be used for housing stability services, and Treasury has defined that term to include legal representation. So that is, I understand that they use the phrase attorney's fees related to eviction proceedings, which is a really odd phrase, but do not let that deter you. That is sufficient authorization to use money for ERAP in our view. No state got less than 200 million in the first round. No state got less than 152 million in the first round. So if you think about 10% of those funds, you're talking about a lot of money that the states have, where they can use a percentage for this, what they call housing stability services. And also we note in here that ERAP 2 has a very unusual provision that says if a state actually spends 75% of its allocation by next October, they're freed up with the remaining 25% to use for eviction prevention or affordable rental housing. So basically really open at that point as far as what they can use it for. So ERAP is a really exciting, so these two pots are very exciting. You can also use at the deadline, you can see the deadlines, ERAP 1 is till September 30th, 2022. ERAP 2 is either 4 or 6 years into the future. The statute is not clear on that, but basically you can see these have long timelines. If you're thinking about a right to counsel, you don't have to do this in 1 year. You can actually look at these funds being spread over a number of years. So ERAP 1 and ERAP 2 in every state are a really exciting and viable source to expand tenant representation and pursue a right to counsel. And the last one, the Fiscal Recovery Fund, this was in the American Rescue Plan Act, gave $350 billion to state and local governments. And basically it says that it can be used to respond to COVID-19 or its negative impacts through assistance to households, small businesses, and nonprofits. That's everything. These funds can be used not only just for that purpose, but it has other ones, including like plugging revenue holes. So states are going to have a lot of competition for those funds, but it is a lot of money. And it should definitely be something that advocates consider as a potential source for a right to counsel, especially because that money can be spent for the next 3 years. So that was a lot of information really fast. I can promise you that the 4-pager we send you will have all of that in it with more detail. You don't have to remember everything I said, except to know there are 3 pots. They have a lot of money in them. And you're about to hear how some people have gotten some of those funds to use for their projects. So I'm now going to turn it over to our first project, which is Jim in Michigan.
Yeah, thanks, John. And I have some really basic slides that I will project. And so I'm going to talk about the 2 stages of these federal dollars being used for legal assistance in Michigan, a 2020 version and then a 2021 version. John, are you ready for me to get going here?
Absolutely.
Okay, good. So the 2020 edition was funded with CRF money under the CARES Act, and it created this EDP, Eviction Diversion Program, Rental Assistance Program. And so really quickly, as its origin story of sorts, we worked with our governor in getting her to issue a moratorium against evictions last March. And that was extended several times into the summer, but she grew increasingly reluctant to extend it further, and so wanted to replace it. And so there was discussion about creating a rental assistance program and then a legal assistance component of that program. And part of the motivation for that was a really good eviction data study that a program at the University of Michigan called Poverty Solutions issued, showing that Michigan has a severe eviction filing problem, and some of the disparities that John talked about, landlords being represented in more than 80% of cases, tenants in less than 5% of cases. And so we wanted the moratorium to continue, but the governor wasn't interested in that, but became more and more engaged with this possibility of a rental assistance program with a legal assistance piece. And very fortunately for us, that the administrator of our Supreme Court's administrative arm, it's called the State Court Administrative Office, was really instrumental in selling this idea of an EDP, or a modified right to counsel piece in a rental assistance program. He's formerly a district court judge, which is the court in Michigan that handles eviction cases, and became something and created an EDP program in his court and became something of a champion for EDP programs. So what happened in Michigan is that there was a State Appropriations Act appropriating CRF money that created this program, the EDP Rental Assistance Program, roughly $50 million for rental assistance and $4 million for legal assistance. And very helpfully, our Supreme Court issued this administrative order that regulated practice in eviction courts, doing things like mandating a pretrial in those courts, and that judges inform tenants about resources available to them, including these rental assistance dollars. And so this program was run on a statewide basis through our state housing finance agency called MISTA, Michigan State Housing Development Authority. And the legal assistance money went through our state bar foundation, which then distributed that money to legal aid programs around the state. So it was a little rough when this program rolled out because it happened very quickly, but it improved over time. The legal services programs use this money to hire new advocates and as funding for current ones. And the program I work for, NPLP, provided training and support for those advocates, and also provided direct assistance to tenants who did not meet the Legal Services Corporation eligibility requirements. And so, it's fortunate that we had a spot along with this SCAO and the Bar Foundation on the so-called leadership team for the program. So it had a lot of input in the development and evolution of the program. And unfortunately, not always, but mostly our housing finance agency was very receptive to that input. And so the experience varied a bit from court to court. Many courts had already had EDP programs, many didn't. There was some resistance in some courts to this increased presence of legal aid advocates and to these Supreme Court mandates. But even it was remarkable and I think heartening in many cases that judges who'd been very skeptical about this program grew to support it and became advocates for it and recognized its benefits, both for managing their dockets, but also to tenants and to preventing evictions. I think some judges who really not had much interest in doing that recognized the benefits and got some satisfaction from doing that. So, it was a mixed experience. The process worked better in some places than others. In some places, this program at the local level was administered by HARAs, so the Housing Assessment and Resource Agencies. If you're familiar with the homelessness programs, that's kind of the single point of entry, and also then community action agencies. And so they had some growing pains as well in administering this program. And so there's some frustration from courts, from landlords and their attorneys, but on the whole, it was a favorable program. And and there is data to show that. So this is some data from the Michigan State Bar Foundation and so this was over the course of 5 months in 2020 that this additional funding enabled legal aid programs to assist more than 15,000 tenants, that the outcomes were very good. In these cases, you can see 97% of tenants assisted avoided eviction. So that this number, 30% of tenants in eviction cases getting legal assistance might be a little overstated because some of these cases didn't result in eviction filings, but even so, I think the increase in the number of attorneys who got representation went from that under 5% to more than 25%. So it was a substantial increase. And there was widespread recognition of the value of these programs. And so that has carried over into 2021. And there was really no question, despite MISTA, who is now administering the ERAP funds, being very cautious about overstepping any of the Treasury guidance. There was never a question about legal services, legal assistance being a part of the 2021 program of our ERAP program, which we call CERA, the COVID Emergency Rental Assistance Program. And so we'll see. Our legislature, and it was a bit of a political circus, was late in appropriating these ERAP funds, but we're now starting to see this program being implemented. There's an online application, which I think will make the program more efficient as well. One of the other pots John mentioned is ESG. There was $2.3 million allocated from MISTA's funds for legal services and $7 million so far this year from the ERAP funds for legal services. So almost $10 million. That number will probably go up from ERAP 1 and almost certainly then be added to by ERAP 2. So certainly a challenge is the permanence of funding, as John said, with ERAP 2, that there is more not permanent, but longer term funding that is likely available. That the temporary nature of funding has presented a lot of challenges, both in terms of hiring and retention of new advocates who are a little distressed about the term of their contracts, sometimes 1 year now, sometimes 2-year contracts. And so that's an issue. The burnout factor in the 2020 program was fairly high. So that is a consideration, I think, in programs. Unfortunately, in Michigan, our legislative climate isn't especially good for doing right to counsel on a statewide basis, but still, I think the experience with this program among many stakeholders, including some, really, I'd say many legislatures, has been very favorable, and certainly with MISTA, the state agency, and in the governor's office. I think another bit of a challenge we have is in making clear the connection between EDP and right to counsel, and that they are on a continuum. So, and I think we've made some really good progress on that continuum, but aren't at the point of right to counsel. But I think there's growing recognition of that connection. So I think really on the whole, it's been a favorable experience, and the outcomes are pretty irrefutable. So I could say more. Why don't I leave it at that for now, John?
That's great. And, your comment about, the continuum is exactly how we see things as well. Even if it does not immediately say that every tenant has a right to counsel and here's enough money to do that, it starts building the culture for right to counsel. The more that representation expands, the more that right to counsel is part of the rhetoric of what's being aimed for, the more that that legislators have that concept in the mind of where we're trying to get to, the more that this can really be the seeds for right to counsel in the future. And in fact, that's how it's happened in jurisdictions that have passed a right to counsel. Often they started with an expansion first, and that built eventually to a right to counsel. So thank you, Jim, so much. I know there is a question in the chat for you if you want to answer that. And in the meantime, we will actually move on to Jennifer in Rhode Island. And Jennifer, I'll just ask you to start off with, if you can just say how much funding you have and what the pot is before you sort of explain the details, that would be great.
Sure, absolutely. No slides from me, so I'll just try and give a brief summary. In Rhode Island, we started with CRF funds in 2020. That program was administered through our Commerce Corporation, which is a cabinet level agency in Rhode Island. And it was a small investment of about $200,000 in expanding eviction defense and legal assistance to participants in the CARES Act funded rental assistance program that we had here in Rhode Island. That was referred to as the Safe Harbor program and was administered by United Way in terms of application and review, but was managed by the state agency, which is our Commerce Corporation. Fast forward to 2021 with ERAP 1 funds. The management of the program moved from the Commerce Corporation to our Rhode Island Housing, which is our housing finance agency, similar to Michigan. And that quasi-public state agency issued an RFP for legal services. Because we were in round 1 with CARES Act funding, there was never a question in Rhode Island as to whether legal services for rental assistance participants would be important to fund. The value proposition had already been demonstrated because there were so many complicated legal issues that arose as courts were open, courts were closed, shifting moratoria at the federal level. And it became I think was very evident quickly to state level decision makers in Rhode Island that they really wanted to have legal services as part of the rental assistance adjacent programming, particularly because like in Michigan, our governor did not wish to issue a state level eviction moratorium through executive authority or otherwise. And I think that there is a trade-off between the willingness to take other actions to prevent eviction during a global pandemic, for example, and the desire to get, in the absence of that kind of a complete protection, to at least get legal services available to tenants who may be facing eviction, particularly at such a fraught time. So the RFP was issued. There was, because of some history that I'll share with you in a minute, the only two legal aid providers in the state who provide eviction defense, which is Rhode Island Legal Services, which is our LSC funded program, and the Rhode Island Center for Justice, the program I direct, which is not LSC funded, joined together and responded jointly to the RFP. And we were authorized to provide $500,000 of additional legal assistance adjacent to what is being referred to as Rent Relief RI, which is the ERAP funded program in Rhode Island. So that's kind of the scope. We use that for capacity building. We both agencies proposed to add attorneys and paralegals to expand the legal assistance available to tenants facing eviction and who have contact with the rent relief program. So I wanted to double back a little bit now to build up a little bit of the history about why this has been framed in Rhode Island as a right to counsel initiative incrementally. In 2017, our program had already been applying to the traditional CDBG program in our capital city, Providence, which, for those of you who are at all familiar with Rhode Island, we're kind of a city state. That's a bit of an overstatement, but the vast majority of evictions that occur in any given year in our state happen in the district court that it has jurisdiction over, our capital city. And so we had already been doing a very small amount of work funded by CDBG funds. And I used to joke with our staff that it was almost not exactly worth it to apply for the $10,000 that we got from CDBG because it took more than $10,000 of my time to do all the paperwork. But in hindsight, I'm very, very pleased that we were involved with CDBG before the pandemic and already understood the program and how it operates and had a known relationship. We had always envisioned it as a way to begin very slowly, very incrementally to build towards right to counsel. And so that turned out to have been a really good kind of early investment in this logic as we developed that further. Because in 2018, we brought together a right to counsel kind of working group in Rhode Island comprised of Rhode Island Legal Services, the Center for Justice, our Housing Works RI, which is kind of our data and analysis entity in our state, and the Pro Bono Collaborative of the Roger Williams University School of Law, which is the only law school in Rhode Island. And so that coalition, along with some housing advocacy groups, has been looking at the New York City initiative and looking at other initiatives nationally since 2018 and trying to figure out how we've made a few forays into our legislature to look at statewide right to counsel. And in 2019, the mayor in the city of Providence, Mayor Lorza, announced a small initiative to work towards right to counsel in the city and issued an RFP for $300,000 for legal services to expand representation to low-income tenants. We jointly applied at that time and were successful in responding to the city's request for proposals and are working currently in that partnership as part of that working group to expand representation in the city of Providence. So we had a lot of conditions of readiness in place to respond when the pandemic hit, when the first round of funding came down under the CARES Act, such that that was already a known thing that was happening in the city. So the Commerce Corporation actually reached out to us rather than vice versa. And at first I couldn't quite figure out why they were recruiting us to receive funding to do eviction right to counsel. But because of some other political decisions that I referenced in terms of a relative unwillingness to do things like a wide-scale moratorium, I think that the state government actors were really interested in making some investment in tenants and in tenant defense to kind of compensate for other choices that were being made. So fast forward to the present, we've applied for and been approved for ERAP funding. The way Rhode Island is doing it is that those funds are for the calendar year 2021, but we've already been informed that there will be a next round through ERAP 2. And I think we really confronted a lot of difficult decisions when we talk about the sustainability of these efforts, utilizing these sources of funds. And initially, I had some concerns, certainly about applying for ERAP 1 funding for what would be less than a full calendar year, staffing up to provide the services, and then potentially having to lay everyone off in December. But because of the changes in terms of how these funds have been structured at the federal level and the availability of the next round with ERAP 2, those concerns have really become much less acute for us as legal aid and legal services providers. And now we see kind of a runway up to 3 to 4 years between ERAP 1, ERAP 2, continuation of CDBG funding. So we're really starting to see a narrative in which we can build out right to counsel in the state of Rhode Island in a pretty meaningful way over the next several years. And because all of the successful right to counsel initiatives nationally have been incremental, it seems like we are now on a path to utilize these funds and others to really achieve a statewide right to counsel initiative that initially will not need to go with legislative approval, as has been done in the 8 states that John referenced up front. But we have a pathway to build it and to kind of demonstrate, I think, to our legislature through the use of these federal funds that ultimately in 2025 or 2026, it will be very sensible for them to continue to build and or sustain these efforts at the state level.
Thank you. That was tremendous. And I think you really tied it all together and made the right to counsel, piece of it fit, in explaining that. And I especially note you're saying that, because you had this connection with the state from the first round, you were already in position. And that's going to be so important with all of this work is, getting in the door really starts to build those relationships and make, make the right to counsel advocacy in the future so much easier because you're already a known quantity to them that they're providing money to. And it just works so well. Did you say, Jennifer, that the first round of money you got from last year, was that CRF that you got?
Yes, so there were actually 3 sources during 2020. CRF funding, we already had applied for what I call traditional CDBG and had a small investment there. And then CDBG CV, which was the additional CDBG funds that came during 2020. So all 3 of those funds were tapped for tenant representation. And I think that my biggest point, I want to emphasize what you said, John, is that the value proposition of this work was already demonstrated during that first round. And so there really wasn't a question about whether the state wanted to fund right to counsel with ERAP funds, but kind of how and at what size and so forth.
Thank you. Thank you very much. We'll turn now to Hazel for Cleveland, or rather for the county.
Hi, everyone. So I'm going to give just a 2-minute overview of where we are with right to counsel, because I think it puts it in context as to where we're going, where we're hopefully going. So in 2017, we had a local foundation that had a call for ideas that would have a high impact on poverty in the city of Cleveland. It was one of their anniversaries, and they were trying to fund programs or projects that would impact the city. We put forth at Legal Aid, which we are the only legal services provider in the city of Cleveland that does this kind of work, and also an LSC funded organization. We put forth an application to provide for two ideas. One was the right to counsel in eviction cases, and the other was a process to seal eviction records. And so from that, I became the fellow, and we worked pretty extensively on developing what right to counsel might look like in the city. At the time, because the fellowship was within the city of Cleveland, that's where our opportunity was and where we were focused. The city was also doing a community read of the book Evicted. And so we spent a lot of time in the community talking and educating both our partners, but also our stakeholders and our council members and sort of policymakers about the impact of eviction and sort of the downstream consequences and the potential return on investment. So we spent that time between late 2017, most of 2018, doing that work and creating some coalitions to support the effort. And really that has paid off in that when we go and talk to our partners, they sort of know already what is right to counsel and what that means in our community. And so fast forward to the end of 2019, the city of Cleveland passed an ordinance that does provide right to counsel, but it's a narrow population. We really, there was a, and funding was definitely an issue at the time. And so what we ended up doing was an ordinance that provides legal representation for tenants at 100% of the federal poverty guidelines and who have a child in the household. And so that was what the right and who was entitled to the right. And it became effective July 1st of 2020. So really, sort of shortly after the pandemic started, we were launching this program. So I think similar to some of what Jennifer just talked about, we were positioned in a way where we were ready to launch the program. Our funding had at the time included and does to date include a portion from the city, but also from philanthropy. And so we were in a place where we were positioned to launch the program and provide the service. Our hiring had already happened. And so in 2020, we received some funding for eviction defense work. That was CBDG, both the traditional version, but also the CARES Act funding. And so fast forward to, now 2021, so that's for the city of Cleveland. So let me pause there. The county of Cuyahoga, which is where the city of Cleveland lives in, is there's a bunch of different suburban courts that also hear eviction cases. In fact, they hear about half of the eviction cases in the entire county. And at the time when we were sort of advocating for right to counsel, we really also had conversations with folks at the county level and educated our stakeholders on what does right to counsel mean, and really try to educate, because some of the cost savings were really going to be seen by the county, not necessarily by the city, because of the funding structure. And so that was pretty much where we were at in our conversations with the county. But then just recently, the opportunity presented with all of the new Treasury funds that are coming through, and the county has awarded legal aid $1 million for eviction defense work in the county of Cuyahoga. So this is separate and apart from the right to counsel that exists in Cleveland. Our hope and our vision is that that will manifest into, it's not going to be enough obviously for there to be a full right in the entire county, but there might be enough for us to pilot a program or take some of the lessons that we've learned in the city and figure out how does that work in a more broader county level with a bunch of different courts operating at the same time. And then in addition to that, our hope is, so that was from the Treasury funds from the December Act. So hopefully there will be more funding coming through that will give us the opportunity to model this more broadly in the coming few years. But we really are, hoping that this will be at a level where the expansion becomes so institutionalized in our community that it just becomes part of the ecosystem of housing people and keeping them stably housed.
That's great. So just to clarify, I think you were saying that, this first appropriation came from essentially from ERAP 1, and that you're hoping to get more when ERAP 2 comes down the road, like essentially, is that right?
That's our hope.
Great. And yeah, I think, Cleveland is a perfect example. Again, it already has a right, and then it's building towards something bigger. And like you said, being positioned as you are, because you already have those relationships with the city because of the right. It all really lends itself well to building something bigger. So it's a great model. Did you have anything else you wanted to add for the county?
No, I think what I'll say is that, what I mentioned now is for the county. And because that does not include Cleveland, we also hope that there will be an expansion in the city of Cleveland, recognizing that the right itself is relatively narrow. And so to the extent that some of these funds could be used to, to create that expansion in the city, we're definitely listening and learning and trying to see what opportunities there will be.
Terrific. Thank you. We will now move to Barbara to talk about Long Beach specifically. And if you wouldn't mind starting as others have done with how much and where it's come from, and then getting into the rest, that would be fantastic.
Sure. For Long Beach, it's coming from the American Recovery Act, and I'm assuming it's ERAP too, but I'm not entirely sure. And it is $900,000 for eviction defense and prevention, and $30 million for rental assistance. So just to give a little background, we have in Los Angeles a Renters' Right to Counsel coalition that's been going for almost 3 years. And we have in Los Angeles, there are 89 different jurisdictions, which always makes it fun to try to get programs and or legislation passed. So the coalition was primarily focusing on LA County and the city of LA, which are the largest jurisdictions. And we had gotten a contract with the County of Los Angeles in 2020 for $7 million for eviction defense, prevention, and rental assistance. And the city of Long Beach decided at the beginning of this year to kind of start a pilot right to counsel program. And they sort of kicked in $250,000 from into the county contract for Long Beach residents specifically. Let me just share my screen here. So for a little background, the city of Long Beach is probably the second most populated city in Los Angeles County with 500,000 residents. It's a very diverse city. As the Long Beach advocate who wrote this noted, it is often shadowed by the city of LA and the county of LA. So there is a separate coalition, apart from the Right to Counsel, the Long Beach People's Budget Coalition that has been working for the past several years. They primarily worked on language access work. And so they started advocating and focusing on divesting and defunding the police for and reinvesting in the community for health, housing, immigration, language, justice, etc. So they had kind of a broad platform, which included Right to Counsel. So they had asked for, I believe, $3.6 million for Right to Counsel, but what they actually achieved, and I just wanted to note the broadness of their platform. Relevant to this discussion, of course, is the $30 million for rental assistance and the $900,000 additional funds for Right to Counsel. Also won quite a few other victories in a broader policy sense. So the Long Beach, we're not yet sure the time period or how these funds will be exactly spent. We're still working on that, but this will join the contracts with the County of Los Angeles, contracts with the City of Los Angeles, and our contract with the City of Santa Monica. So what we're trying to achieve, of course, is a broader Right to Counsel throughout all of Los Angeles and its 89 jurisdictions.
That's great. Did you just, and actually, if we have a few minutes, I'm going to pose this question to others as well, but just in thinking about, has there been anything in particular that you've sort of argued that has really resonated with the policymakers who make these financial decisions?
houselessness is such a huge issue in California and particularly Los Angeles. There was a great deal of money put in to what they call homelessness prevention. But what they discovered is they kept getting people housed, and guess what? More and more people became unhoused. And of course, a lot of that through evictions. So that has been a compelling argument for us. I should also note that the California as a state has a bill to fund local jurisdictions for their right to counsel efforts. We've just passed the first committee for that, but I imagine that they will be looking at the federal funding to fund that.
Thank you. That's great. Well, I'm going to turn it over to Ugochi now to talk a little bit about Santa Ana.
Thank you, John. Good morning, everybody, again. So in the city of Santa Ana, I do want to first acknowledge the hard work of our community organizers. They have really been working nonstop to make sure the tenants are protected in the city of Santa Ana. The city of Santa Ana has a large percentage of its residents who are renters. About 60% of the individuals who reside in the city of Santa Ana are renters, and a large majority of those individuals who are renters are well below the poverty guidelines. And so prior to the COVID-19 pandemic, there were a number of tenants in the city of Santa Ana who were experiencing housing instability due to high rents, and we don't have strong local protections for tenants at risk of eviction. And so with this pandemic, with this unfortunate pandemic, it did create an opportunity for organizers and attorneys to get together to present the needs of residents to the city. So during the earlier days of the pandemic, the organizers were able to secure from the city a moratorium on evictions related to non-payment of rent, and also a moratorium on rent increases, which at least helped to stabilize some tenants while we were waiting for the stronger tenant protections that my colleague Barbara Schultz mentioned earlier in her presentation. So since the COVID-19 pandemic, we have been working with our local city jurisdiction to ensure that tenants remain housed during this pandemic. Prior to the pandemic, we did receive CDBG funds, and we still continue to receive the Community Development Block Grant to provide housing assistance and legal assistance to tenants at risk of eviction or in need of housing related needs in the city of Santa Ana. And then with the CARES Act money that was mentioned previously in John's presentation, the city of Santa Ana created a program where they provide rental assistance to tenants, one-time rental assistance to help provide rent, and so that the tenant's not at risk of eviction. Then with the expansion of the CARES Act money to provide CDBG CV money, the city of Santa Ana was able to continue that program. So they do continue that program. It's called CARES in our jurisdiction, because the city really wants to ensure that people who are at risk of eviction are not evicted from the city of Santa Ana, if at all possible. That created an opportunity for our organization, the Public Law Center, to partner with the city of Santa Ana and a local provider, the Salvation Army, to help provide legal assistance for tenants who are running into resistance from their landlords who are not taking the rental assistance funds. That program is called SAVES, and it is funded through, in large part, with ESG CV funds that came as a part of the initial COVID relief package that the Congress passed in 2020. With that money, we are able to provide legal assistance to individuals who are running into, as I said earlier, resistance from their landlords not taking rental assistance funds, helping to provide technical guidance to the Salvation Army, the rental assistance provider, who is providing those funds to the landlords, and to have discussions with both the City of Santa Ana and the Salvation Army to help ensure that the program is administered in a fair and race equitable way. And so in that last piece, the race equitable way, the tenant organizers that I mentioned before commenced a meeting with the City of Santa Ana to help ensure that the funds that are provided to those who are most in need, and those who have been most in need in our jurisdiction have been people with disabilities, people who are people of color, and large families. And so as a result of the community organizing efforts with the city and the joint efforts with the city, we were able to expand the outreach to where tenants can apply for the assistance. So they can apply at nonprofit organizations, local agencies, and our city is working with small landlords to help them understand what this program is about so that they can fully participate. So we have been able to assist a number of tenants to avoid eviction with this funds. We've helped some tenants who have been able to relocate because that's their desire to relocate, and tend to receive additional funding of at least a year to ensure that they remain stable, and they receive a case manager throughout the process so that they can ensure that they remain successful. So we've been able to partner with the city. We received a $250,000 grant to provide legal assistance, and we continue to provide that legal assistance and look for different ways to partner with the city to protect tenants. Our city did also receive emergency rental assistance funds. They are self-administering those funds and prioritizing funds for people who are at least 50%, and I'm speaking about the city of Santa Ana, 50% or below of the federal poverty guideline, up to 80%, and along with small landlords. We do have in our other jurisdictions, because we have 34 cities in Orange County, they are participating in ERAP through the county. And then the other two, Irvine and Anaheim, they have a hybrid program where essentially they are providing assistance to tenants based on a prioritization of low-income individuals, and then working with the state to prevent duplication of resources. So we do have a large county in Orange County, but we are working with the city of Santa Ana to provide legal assistance to individuals who are at risk of eviction. Thank you.
And you know, one thing that's notable about this is that while the CARES Act was passed back in March of 2020, your ESG appropriation just happened pretty recently. So in 2021, is that right?
Yes.
Right. So that, and that's just an example of what we were talking about earlier, that this money is still out there. It's not, you know, the CARES Act money is still out there in many jurisdictions to tap into, in addition to these new ERAP and FRF pots. So that's really exciting. Thank you so much. There's an interesting conversation going on in the chat. We have just a couple of minutes left, but I want to pose this to my panel. The degree to which, if you do this work with these funding sources, that you have to show that there's a connection between the tenant's eviction and COVID, and how much that's affecting your work based on the funding that you're getting. Obviously, if you have other funding that doesn't require that connection, can you just handle those other cases with your other funding? Is there a way you can just, like, those limitations don't wind up being a huge problem? How do you see those limitations? So anyone who feels like chiming in from the panel, please feel free to do so.
I can respond. I responded in the chat as well. We have one contract that we're just going to start on May 1st that does require a COVID impact. So we created a very broad definition, which includes, like, if if you didn't get this assistance, might you be COVID impacted because you would be unhoused or living with friends? So we have, we tried to really broaden it. And I agree with the speaker that mentioned the onerousness of using CDBG funding. So we do have our other contracts that aren't CDBG, so we can probably shift people over to that funding if necessary. But with the CDBG funding, you also have to show documentation of income, which is really difficult.
Thank you. Jennifer?
Yeah, we've definitely been monitoring this flexible application of eligibility standards for the rental assistance and therefore derivatively for our legal assistance versus the more flexible interpretation of the guidelines. I would note that there are no regulations issued interpreting these issues for ERAP 1 at this point, nor were there ever regulations issued to make this interpretation for the CARES Act funds. So we had a pretty good ability to make some policy arguments around this. And frankly, when state level decision makers in Rhode Island saw that very few tenants were accessing rental assistance at the peak of the first surge of the virus in 2020, I think practicality kicked in. And early on, people were being required to submit two paycheck stubs, like to show that you had income and then your income was reduced or your hours were cut. People were unable to access documentation from employers who were shut down by the pandemic. So that became a huge set of barriers, frankly, for people to efficiently access the very assistance that was most needed. So really using a public health lens, we began to just make the argument that if someone had an eviction filed, was facing court action, had some kind of illness in the family, had to be home due to kids having their school closed, whatever that nexus might be, it didn't need to have extensive documentation. It needed to be articulable, and we argued for self-attestation. And we were largely successful in right through the end of, well, actually up to March of this year, with that more flexible interpretation as it relates to the CARES Act funding. We're now launching into round 2 with ERAP funding, and we're being very diligent to try and maintain that flexibility. And I think it's going to be an emerging conversation in each state with state level decision makers, whoever's administering those funds, to argue for flexible interpretations of eligibility.
And just one thing I'll add real quick before last thoughts from our panelists on this question is that one thing that's interesting that you can point out is that the moratorium, the CDC moratorium, does not require proof of a COVID connection because the CDC recognized that evictions are dangerous. And the same is true. There's nothing that makes that any less true than when a tenant is applying for ERAP and is facing eviction. It's the same. It should be based on the same policy thought process as the CDC moratorium. I don't know if Jim and Iguchi, if you wanted to add any last thoughts on this question.
Yeah, go ahead, Iguchi.
Oh, sorry. Oh, no problem. I was just going to say for our ESG CV funds, we just have to show an immediate risk of homelessness within 21 days. And so there's no COVID connection per se. What we've been able to do through our providing technical guidance is helping the rental assistance program and the city understand what the risk of homelessness means, so that even if somebody receives, like, for example, a 60 or 90-day notice, that they are in immediate risk of homelessness, because if they're not able to resolve their issue, the next step is an eviction. So we have been able to creatively work within the guidelines to help tenants who don't have like proof of income and documented income, like figure out different ways to help them prove that they are in need of the rental assistance, and then also show what that immediate risk of homelessness looks like.
Thank you. Jim?
Yeah, I was just going to quickly add maybe a bit of a variation on this issue of potential structural or practical programmatic limitation for legal services that are built into rental assistance programs, is that the legal assistance can be primarily for tenants defending non-payment of rent cases. So, I mean, there is this other category of termination of tenancy cases which it may be harder to justify providing assistance to tenants in through rental assistance dollars. So that's a consideration. Unfortunately, our standard in Michigan is if payment of rental assistance will resolve a termination of tenancy case, that it can be made. But there is that category of cases that it may be harder under a program to justify providing assistance to tenants in.
Well, we've come to the top of the hour, and I first want to just thank my speakers, not just because they have done an incredible job in obtaining these funds to advance the right to counsel or tenant representation, and not just for joining us today, but also we had an incredibly tight time frame to have 5 speakers speak and convey information, and you guys really did an incredible job at conveying so much in such a short time. We will be following up with everyone who's registered to provide a link to the recording, the slides that were used, some of the references to the resources that we mentioned, the 4-pager. That will all go out in due time to everyone. And hopefully we'll do this again in 6 months and see what other people have gotten and where it's all going for right to counsel and otherwise. So thank you so much for joining us today on behalf of the National Coalition for Civil Right to Counsel and the National Housing Law Project and the National Income Housing Coalition. Thank you so much for joining us today.
Thanks,
Thank
Jen.
you. Thank you. Bye-bye.